Thank you all very much for coming. My name is David Wilkins. For those of you I haven't met, which I think is a lot of you, because I think we have a lot of first-year students here, I am the faculty director of something called the Center on the Legal Profession, which its goal is to do exactly what it sounds like, which is to try to both study and teach about the profession and to give students an idea of what are the opportunities and possibilities for professional careers, but also to talk about the complex and interesting issues that lawyers often find themselves in the middle of. And my guess is today we're going to have a good opportunity to examine some of those issues. Before we get started, just a couple of housekeeping rules. This is being both recorded and live streamed. The only people on camera are Viet and me, and students' voices also will not be recorded so that, except to the extent they get picked up by our lavalier mics, these are the only mics that are hot. And that's why when we get time for questions, and I promise we are going to save a very good amount of time for questions from all of you, and Viet has generously agreed to answer any question that people have for him here. I will repeat the questions because there are a couple of thousand people on the live stream, and my guess is many more will watch after that. Which is an indication of why I'm very delighted that we're having this event here today. Let me just say a little bit by way of background. I first met Viet as on the very first day of his law school experience in 1990 in civil procedure in the old Harvard Law School, which means there were 140 people in his civil procedure class. I think we were in Langdale North or something like that. I had a giant seating chart in front of me just with names on them. We hadn't even figured out how to pick pictures on them. And in typical Harvard Law School fashion, I was going to call on a student to recite the facts of the case, which I think was Goldberg versus Kelly at the time. And I looked down on my, which it probably still is for many of you today, and I looked down and I saw Dinh and I said, Ms. Dinh, please, and it turned out Ms. Dinh, sheepishly, there was a silence and then a sheepish hand, I'm Mr. Dinh. And that's how we first met. We became quite close that year because, as some of you know, and we'll only talk a little bit about this in general now because we have many more issues to cover, but I think it's well worth knowing. Viet has an incredible personal story. He and his family literally escaped via a boat from Vietnam after the fall of Saigon. He had arrived in this country basically and worked picking vegetables in his early life, first maybe in Texas before moving to California. Where was it? Oregon, before moving to California, where he was, quite frankly, discovered by a teacher who said, you know, you are really bright. You should have higher aspirations than he probably thought he could ever have for himself. And he ends up coming to Harvard College and doing exceedingly well, and then coming to Harvard Law School. But by the time we met, his sister, who had stayed behind when his mother and several of his siblings had left on a boat, had stayed behind because his father had been imprisoned, and she wanted to stay there with him. And she stayed, and eventually her father escaped, and eventually she escaped, but she was caught in a Hong Kong refugee camp. And so at the time we met, and I'm not quite sure, I think I was having lunch with all my students kind of in groups of 10 or something like that, and we talked and he told me this story, and I said, well, let me see what we can do to help. And so we spent much of the next year enlisting people who we knew who were in the Bush administration, the H.W. Bush administration at the time. Bill Alford, who Viet just met, who wasn't unfortunately able to be here, also chipped in, as did several other professors, and we managed to get his sister out of that refugee camp. And we've stayed in touch ever since. I think it's fair to say we don't agree on everything, and that may come out here. We have different views on a lot of different kinds of things, but he remains one of the most extraordinary people that I've met. And when we were in touch around the death of Charles Ogletree, which was also a mentor of Viet's when he was here, and was a dear friend of mine, I said to him, Viet, you know, if you're ever around, you should come and talk to students about some of the issues that you have been dealing with. I'm sure there will be tremendous interest, and the fact that there's kind of standing room only in the back of the room shows that there is indeed. So as I said, I promise there'll be lots of time for questions, and Viet has graciously agreed to answer any question or at least engage with any question that anybody has. But we're going to start out by talking a little bit about how he got to his current position as the general counsel at Fox, and then some of the issues that he's confronted there and what the role of the general counsel is in those issues. And this is partly my interest and our interest in the Center and the legal profession, is to talk about what is the role of lawyers, particularly general counsels, which is a role that there's been, quite frankly, very little, even today, attention to, especially in law schools. And yet, I'm going to argue, is one of the most important roles in the legal profession, because general counsels sit at a very interesting place between law and business. And I know we have a lot of members of the Association of Law and Business here, between internal facing in the company and external facing in the world. They encounter many, many important public issues. And the question is, what's the role of the general counsel in those sorts of issues? Because they're not the owners and managers of the business, they're not the clients, and yet they play a very influential role. So with that in mind, Viet, I'm going to start here. Before you took the role in Fox, you had pretty much every job anyone could have in the legal profession. You'd been a law clerk, including on the Supreme Court for Justice O'Connor. You had worked in the Department of Justice as the Assistant Attorney General for the Office of Legal Policy. You had been a law professor for 20 years at Georgetown. You had started your own law firm, which was kind of the first of what we now see several of, which are kind of boutique, Supreme Court focused or appellate focused litigation boutiques. And you had then negotiated the merger of that boutique into one of the biggest, most successful law firms in the country, Kirkland & Ellis, many of you know. So after all that, why did you decide you were interested in being a general counsel?
Great question. Thank you very much, David, for being here. I just want to say, since you brought up the story of my origin story here at Harvard Law School, I owe everything to this place, a whole lot of it to you. You know, it was just, if you know immigration law or refugee law, you know that people who come into a country is not entitled to any rights because there's an exclusion doctrine. And so my sister's being held in a detention camp just in the New Territories in Hong Kong, and there was no way for us to get any legal recourse. I remember Bill Alford hooked us up with a Queen's Counsel and a solicitor in Hong Kong. Talked to David and Anne Marie, who were very, very helpful navigating the non-legal advocacy, if you will. And it was their idea that I wrote. I sent in an op-ed piece in the New York Times to Anthony Lewis, who has great ties to this place, who then got his editors to publish it. And that we worked with television networks and the like, and David and Anne-Marie guided us in every single step of the way. The day that we landed in Hong Kong with the Dateline NBC news crew was the day that the Hong Kong government released her from detention camp in order to process her as a refugee. So, very early on, David at Harvard and all the people, Deborah Anker, who's the immigration expert, that navigated the U.S. immigration process, taught me early on that what we learn in the classroom can be amplified by a whole lot of other mechanisms to do law. What we advocate in the courtroom can be augmented with a whole lot of other tools in order to solve clients' problems and to get to the desired result. And so, in all of those various stops along the way, and I do admit it has been a bit of a peripatetic journey, that in each one of those, I called on the same essential set of skills, which is the critical thinking, the logical the advocacy, not through fist pounding, but through the exploration and exposition, and ultimately to solve problems using a whole variety of tools that are at your disposal. By the time I joined the company as chief legal officer, I had been on the board for 15 years. So I joined the board of the company in various iterations. It started out as News Corporation, and spun off News Corp, and we became 21st Century Fox, and then we sold 2/3 of that company to Disney, and then we were starting the Fox Corporation, which is the third iteration of the company, with a blank sheet of paper. And one of my good friends, whom I got to know on the board, became CEO, and he asked me to come and take up the current position. You're right that it is a bit of a deviation from the journey that I had before, which, if you notice, it's multi-client, multidisciplinary, multi-ventures. I had many fingers and many pots. And it is a bit of a difference to be focused into one corporation, one client, one set of issues. But it was very exciting because we were building it from scratch. And we were building it together as friends, as colleagues, together as a focused operation. And so it was a very natural professional move for me, and it's also personal. My mom had passed away about a year before, and I wanted to be moved back to be closer to my dad, who's now 92 and thriving, and that to me one of the best decisions I made. And so it's a mix of both personal and professional. Now that it's 5 years on, my ultimate boss, Rupert Murdoch, has announced that he is retiring from the company. We also had our independent director retiring from the company. We thought it was time for me to go back to my roots as a multi-venture, multidisciplinary, multi-client journey, and now that the company's well established.
So Viet, that multidisciplinary, multi-facing, multifunctional idea is one I want to pick up on, which I think will lead us into some of the substantive discussion. That is, I said general counsel is a unique role because of where it sits, but often, and this was the case with you, you had multiple hats. So in other words, you were the chief legal and compliance officer, but you were also the chief policy officer. You were also head of government relations and public relations. And you also sat in as a member of what I think is called the Office of the Chairman. And can you say a few words about how you think about those multiple roles, particularly the aspect of those roles that are legal on the one hand, right? If you think of yourself, oh, I'm the general counsel or the chief compliance officer, that sounds very legal in ways that the students, I think, can understand. But when you start talking about public relations, government affairs, strategy, all those other things, and how did you, what are the lines between where you are as a lawyer and where you are in these other roles? And how is that in turn distinguished from the people who are making the substantive policy, business decisions, editorial content, whatever, for the network itself.
Right. And so Fox Corporation is a bit more than Fox News. We have the Fox Broadcasting Company. We have the Fox television stations. We have this direct-to-consumer service called Tubi, which is a free ad-supported streaming service. But the core of Fox is the Fox network, which brings you the NFC football every single week. Unfortunately, this last week, the Eagles did not comply with with our programming needs. And of course of that that includes Fox News and Fox Business. Fox Corporation, our corporate entity, oversees all of these business units, but uniquely each of the business units themselves are overseen by their own management tools. So we have a CEO of Fox News, we have a CEO of Fox Sports, we have a CEO of Fox Entertainment, we have a CEO of Tubi, we have a CEO of the Fox television stations, so that all of these units are run locally by the business unit heads. And among the various roles that roll up to me, we also have key colleagues. So for example, the general counsel who's head of all legal is Jeff Taylor, who was here graduated in 1991, was a career prosecutor and was U.S. Attorney for the District of Columbia. So very, very capable lawyers. Before that, he was the Deputy GC at GM, before we enticed him with palm trees and beaches and fast cars. And then our chief underneath him, our head of litigation and chief compliance and ethics officer, again, ultimately rolling up to me, but he oversees all ethics decision as well as litigation, is another former U.S. attorney for the District of Nevada, Nick Trutanich. He was also Deputy Attorney General of Nevada. So we have very capable people doing all of their various function. We have a head of government affairs in Washington, D.C., who's very, very capable. Previously, he was the chief of staff to then Senator Biden for a number of years, and now he's succeeded by another colleague. And so we have all these teams that are very, very capable doing their jobs. And my job essentially is to help Lachlan be the decider in chief. He is the chief executive officer and executive chairman. He bears the burden and responsibility of making all decisions for the company, obviously feeding up through the business unit heads as well as the staff that he has at corporate. So anything that's legal, that's compliance, government affairs, obviously rolls up through to me, and I report to that to Lachlan. The one thing that I am very, very cognizant of, and our lawyers are very cognizant of, is not to misuse our position into a leverage point for business or other decisions. I think one of the key issues when you are a lawyer functioning in a business is quite often one uses one's legal position as a way to impose one's will through the business unit. That to me is not abuse, a misuse of the legal function and your core competency as a lawyer. If you have a strategic view, if you have a business point of view, by all means contribute to that. Nobody has a monopoly on good thinking, but don't say that this has to be done this way because I'm the lawyer and I insist you do it this way. And so I think that we, at least our organization, is very mindful that we don't misuse our legal authority into encroaching into other areas. We don't, that means we all participate in all decisions because it's very collaborative, and it should be, but there's no insistence that I'm a lawyer, therefore it has to be done this way. At times, it has to be, when it is a legal, when it is a compliance, when it is a liability question, then one has to put one foot down as a lawyer and say, you cannot do this, and that word is law, because otherwise significant consequences will follow. But often we're talking about business decisions, and we're all bringing in it together, bringing different perspectives, bringing different considerations, and that's I think that's the key point that your question gets at, is how do I as a business person know when to contribute to the business decision, as opposed to how I as a lawyer will insist on something doing a certain way because the law requires it, or because not doing it another way would impose unacceptable risk of legal or other liability.
So Viet, this brings us to, I think, an issue that every one of the students knows, and that's put you in the, both in the news and maybe in the hot seat a little bit, and that's the Dominion voting litigation and the kind of penumbra around it. Because here you've got something that is both, on the one hand, legal. It's a lawsuit that's been brought against your clients. But it also implicates things that are at the core of what the business model of Fox News is, how Fox News exercises its editorial judgment. And all of these things are wrapped together in this lawsuit, which presumably, as a lawyer, you have tremendous, I mean, you are the chief lawyer running the litigation strategy, and you are also a member of this larger management team. And so can you talk a little bit about that? I mean, obviously there was a lot of publicity around this lawsuit. There was an $800 million settlement eventually around this lawsuit. There was a lot of discussion around what that meant about the underlying conduct.
785 million.
I'm sorry.
But you know, who's counting? So the two distinctions which you've made, which is yes, in the conduct of litigation, the backward-looking liability ascription. I, as the chief legal officer, oversees the entire litigation. We're aided by obviously a very capable set of lawyers, Jeff and Nick, who I've mentioned before, but we have a very capable general counsel of Fox News, Bernard Guger, who was general counsel of Harpo Production before, Oprah Winfrey's company, and he has and a deputy general counsel there who's a litigation partner at Kirkland & Ellis. So we have a very good deep bench in-house, and of course we have, at one count, hundreds of outside lawyers. Probably the best trial lawyer in the country, in Dan Webb, and I'm biased, but clearly the best appellate lawyer in the country, certainly now and of his generation, Paul Clement. And so there was this whole the whole litigation team. Our thesis was very simple. Our thesis was very, very straightforward. We are in the news business, and the 6 weeks following the November 9th elections of 2020 were a incredibly newsworthy 6 weeks. Why? Because you have the sitting president of the United States contesting the result of an election that he lost, and hiring lawyers to go to court in order to challenge the initial election results, and asserting that he, at the end of the day, will have enough electors to overturn the election. And why do I say 6 weeks? Because by our laws, December 15th is when the electors have to be certified by the state legislatures in order to have the House of Representatives recognize it. So it's a very discrete period of time with what I consider to be incredibly newsworthy events. And we, as a news organization, would not be doing our jobs. We have not only the responsibility, but the duty to cover those allegations. It was a live ball, and it was hotly contested. We knew we were right in the law. The trial judge put us in a situation increasingly where It was very obvious that we were not able to win the trial. But we were very confident we would prevail on appeal. And as the judge compounds error upon error, we would get more and more confident in our ultimate chances of prevailing on appeal. Because at some point it became not just a matter of reversible error, it called into the fundamental fairness and integrity of the Delaware the civil justice system. We had a situation whereby I had Dan Webb, threatening to commit suicide in his hotel room because he sees no way to win this at trial. And I've got Paul Clement doing cartwheels in his hotel room saying, wow, I'm going to be the hero, winning this case back for the company and for the First Amendment and American democracy. One example, for example, was the judge ruled that we cannot prove falsity. We cannot prove falsity because the election clearly was won by President Biden. Nobody disputes that, but that wasn't our argument. Our argument is the truth of falsity of the fact that we cover the allegations as allegations. There was no question in our mind that the president was making these allegations. He's doing on TV, on our air and others. There's no question that Rudy Giuliani was making these allegations. There's no question that Sidney Powell were making these allegations. And we, as a news organization, had a duty to cover those allegations. And so the truth of falsity is not the truth of falsity of the allegations, but the truth of falsity of the fact that they made the allegations. And that, to me, is a critical conceptual and legal mistake, the conflation of the two, that led the judge to really, I would say, illogical holdings that we cannot mention the First Amendment, for example, in our trial presentation. We cannot mention the word newsworthiness in our trial presentation. And so those are the kind of things that really hamstrung Dan's ability to present and ultimately to defend the case before a jury. Because we were confident of our position on appeal, the more these errors compound, the more cartwheels Paul Clement did, because his job becomes a lot easier. But it also meant that we're going to have 3 to 4 months of just utter pain with all our witnesses not being presented in court, and Dan Webb not being able to do his job. And you mentioned it, we had 250 reporters in the courtroom because it was a very hotly covered controversy. And so ultimately, even though we were confident, I still am confident, we as an organization are still confident in the legal arguments and legal strategy. The business decision was made to save the organization from the cultural and reputational cost of going through this very long and hard-fought trial. Especially, we are walking into an early primary season of another hotly contested and very exciting electoral process. You see the primary season doesn't start this early normally, but it does. And who do we have as the leading Republican candidate? The same guy who was contesting the 2020 election, right? And so the business decision is to, take the pain so that we can do our job in the next cycle to cover the newly launched presidential election of 2024. And so that's as clear as I can make it in terms of how our thinking went and still goes. It also goes to your first point, your repeating point, David, is that my job as a lawyer is to give the clearest legal advice, make the best legal judgment, hire the absolute best lawyers to advance our case in court, incidentally, to defend the First Amendment of the United States and our constitutional democracy. Not small beer here, but my job ends there to a certain point, and a business decision has to be made as to whether or not the principle is worth the cost to the institution. And so there are limits to the legal position. There are limits to the business judgment. Where what I said before is what I think would be a misuse of power is for me to say, I'm the lawyer, I insist on going to trial, without regard to the business implications, because that's clearly a overreach of the legal position, even though we thought we would ultimately win.
So thank you for that. One of the things you said there that my guess is, again, and we're going to go to questions pretty shortly, I've just got a couple more things I want to ask, is, of course, about the First Amendment and about the effect on democracy. And that was, of course, one of the big issues that people have talked about, particularly in light of what happened in January 6th. And one of the questions about Fox News that my guess is in one sense editorial, but in one sense maybe also legal, particularly with respect to the role of the general counsel, is what is the line between reporting on the news and the news reporting division, of which you could say, what are the results of the election, so to speak, and the editorial content and the editorialization of Fox News hosts.
Yep.
And as a general counsel, presumably there must be legal constraints around both of those things, but they're not necessarily the same thing. And how do you, as a general counsel, what is your role, particularly with respect to the second of these things? Because I think that was the one probably that engendered the most attention and controversy around this issue.
Right. First of all, I do want to make a distinction between the post-election coverage and the January 6th coverage. I think that with all the congressional hearings and everything else, everybody has been very clear that the Fox was very clear in its coverage and very responsible in its air, both in terms of opinion as well as in coverage. January 6th was an abomination of American democracy, full stop, period. We've called that, and every right-thinking American should be saying the same thing. The bigger question you raise is what are the safeguards, both in terms of prevention as well as remediation, do we have around editorial voice, especially as it turns into potential liability. Every single reporter, every single online and on-air talent, and all of their staff goes through regular First Amendment and journalism, basic journalism training, both in terms of actual malice, in terms of law, in terms of best practices. And we do this with editorial, with media lawyers, and with outside counsel. And it's like painting a ship. You just keep on doing it, and then you keep revising, reiterating the training, and you keep on doing it for the entire core of people who are responsible what goes onto our air. The law is very clear that it is the speaker's intent that is at issue in a trial on libel where truth or falsity is at issue, or actual malice is at issue, not the entire corporate intent, because we're a company of 10,000 people. What I think, in the heart of my heart, really shouldn't matter. What Maria Bartiromo thinks is the truth, and her reporting, that's what really matters. So truly, it's just the speaker and her immediate staff of reporting to do their work as journalism is what counts. One of the unfortunate things that happened in Delaware was the judge ordered no relevance review. And so if you can imagine litigation whereby you just throw in search terms, and the judge says nobody reviews anything, just get the data and dump it to the other side. You've got 25 million documents floating out there. Probably half, at least half, maybe 70% of it is completely irrelevant to the case. But now everybody's emails, everybody's texts, including text dealing with how we cover the news in other areas, are now exposed to the world. That's why you have 250 reporters, because we are navel gazing the industry, and there's no better than navel gaze than read other people's texts and just put them out there as in order to feed the gossip beast. And so pretty quickly, I think the process, the court lost control of the media circus to our detriment, and it severely affected our journalists' ability to do their job in an honest and earnest way, trusting the privacy and integrity of their own work. Besides the training, we of course trust primarily the reporters and the on-air people. That is their primary job. No amount of legal review, no amount of supervision will substitute for quality and integrity in the reporting process. And each person has that obligation to make sure that what he or she puts on air, writes in print, is of quality and integrity, and we can stand behind it. There's a difference, of course, between news and opinion. All of our show hosts, it started out prime time, 8 to 11, now extends from, it looks like from 7 o'clock after Bret Baier ends, all the way through the Gutfeld at 11 or midnight. Those are what we consider to be our opinion shows, where they comment on and editorialize on the events of the day. That, to me, is understood as opinion, is protected as political expression at the highest level of the Constitution. And so in many ways, the Constitution gives you better room in order to participate in democracy through opinion. The day parts we report as news, and obviously there is a higher obligation to verify the facts, check the news, and the like. The blend between the two and what our hosts say in the air, that itself, that what we call editorial judgment, editorial selection, that itself is an opinion, right? That in of itself is a deliberate choice to participate in American democracy in a particular way. If the entire media, the mainstream, the industry is taking one view, our deliberate editorial choice is to take a slightly different view, and we say we are the center-right network. We will select stories based upon that point of view that happens to be, in our belief, coincide with America's view, but irrelevant, because we want to fill that marketplace that is severely underserved, and that has worked because it is the most popular, not only news, but cable network in America for 20 years running. And it is a deliberate editorial choice that in itself is protected by the First Amendment. And so just as the New York Times chooses to go a different way, just as the Washington Post chooses to go a different way, just as CNN, if anybody still watches it, chooses to go a different way. Sorry, that was snarky.
So I'm going to go to questions from the audience, but I have one last thing that builds on exactly what you said, because there was no on-air host whose opinion was more amplified and also whose emails were more exposed than Tucker Carlson. And Tucker Carlson eventually was fired from Fox. And so you're the general counsel. I cannot imagine that decision would have happened without it coming to your desk. And while many of the things we've been talking about, you've been critiqued from the left, I'd say there's been a fair amount of criticism from the right about the firing of Tucker Carlson. And how does that fit in with what you just talked about? And in particular, again, what's the role of the general counsel in making that decision?
Right, and the way I will answer it, I apologize, with just a little of a clarification. Okay. Tucker has not been fired. He remains on contract with us and being paid very handsomely by us. And his contract, has a clause that is very common in media contract. It's a pay or play contract, which is that we, as the network, has the option whether or not to put him on air. The only consequences of us not putting him on air is we pay him to be hanging out in Maine or in Florida. And so we, as as the lawyer, we made the decision that was the proper way to handle the situation. It continues to be the case. Obviously, what goes on our air is not my decision. It is a core editorial decision that's made by Suzanne Scott, our CEO. By the way, the only, I think, still, no, somebody else joined, but certainly the most powerful and effective woman executive in the news business, and she's incredibly good at what she does. She makes a decision who goes on air, who doesn't, the kind of personnel decision that she and Lachlan Murdoch, the CEO of the company, make together. That's core business and editorial decision. My job is to execute it from a legal perspective, how best to handle and execute the decision. And one thing very clear: there's been some really bad reporting, both by journalists and one author, that somehow Tucker's not appearing on air was a quid pro quo for the Dominion settlement. Absolutely untrue. Never could enter the conversation. Never part of the settlement. Both we and Dominion have said it on the record repeatedly. I think this is just a complete fabrication by journalists trying to look for a story when there wasn't one there. In terms of the actual decision, obviously Suzanne and Lachlan have spoken elsewhere regarding their decision, but it follows the same train of thought I said before. We are getting ready to cover a very long and very contentious presidential cycle with a whole lot of stuff going on around the world, literally. Russia, Ukraine, Middle East, China, just everywhere. And the same leading Republican candidate that we had just 4 years ago, who still doesn't believe that the president won the election. And so I think that Suzanne want to make sure that we have a very good slate going into this season. And I think Jesse coming into 7 o'clock is a welcome addition. The rejiggering of the lineup has been positive. The early returns are good in terms of ratings and, more importantly, viewer satisfaction. So I think these things are hard, risk-based and reward-based decisions that in many ways is not in my core competency, but it's for the executives who make these. But these are hard decisions. There's no question about it. Tucker was not only the most popular person on our network; he's the most popular television personality, period. In the air, and the ability to take him off the air, everybody knew had some consequences.
So the floor is open. Please. So Viet, sorry, if you don't mind, I'm just going to repeat the question.
It's such a good question. I had to jump into it.
So the question was, if Fox has had for a long time owned the kind of center-right audience, they're now new networks even further to the right. How does that affect not just the business model, but I think you excellently pointed out your legal risk tolerance for competing for that market?
Yeah. The risk tolerance doesn't change because that's I think that's regardless of who your competitors are, how much competition you do, you have to make your own risk tolerance as to what's right and what's acceptable. The motivation is more subtle, right? Are there more subtle pressures to move away from your lane? Are there more subtle motivations to cut corners? Even though our tolerance doesn't change, doesn't mean that we don't recognize the facts on the ground when you're running full speed with competitors chasing you, that you might be cutting corners a little bit faster than you would otherwise. I kind of like that, to make sure that our brand, our company, and our people remain focused and competitive. I like to say that there's nothing that focuses the mind like than an arrow pointing at your head. If somebody is, when you're getting really motivated is when you're in competition. That's why we play sports. And having competition both from the left as well as from the right means that we have more participants into the public conversation. And unlike a winner-take-all market, this to me is the more participants there are, the more interesting the conversation. And so I truly mean it when I say I welcome the competition in the marketplace of ideas, because that expands the marketplace of ideas. It makes it more interesting. It makes our product more sharp and more focused, and expands the potential number of eyeballs. And so the news business and the entertainment business is, to me, one of those things, because we're not just competing against other news outlets. We're competing with what is it, World of Warcraft?
Or Succession.
That's fiction. That's entertainment. But great question. Really, really good question. Yeah.
Thank you. Yes, please, here. So again, just to repeat the question, and for those of you who don't know, when Viet was in the Bush administration after 9/11, he was one of the chief architects of what's been called the Patriot Act. And I think the question was, looking back now, Viet, we've now had more than 20 years, and also looking forward in terms of what's happening in the world today, maybe how do you think about the balance that was struck with that act? And what are the implications moving forward as technology allows us to be much more intrusive in terms of surveillance than was certainly the case when you were thinking about those issues in 2001?
Right. Great question, but just as a matter of historical accuracy, a lot of what we now think of as the USA Patriot Act is not just the USA Patriot Act, which was a set of limited 40 provisions to be sent to Congress that was ultimately passed 99-1 by the Congress, nearly unanimously by the House of Representatives, and has been almost unanimously and consistently reauthorized by Congress for the last 2 decades. It is a limited set of governmental powers and restrictions in order to ensure that we have all the legal tools that we needed to prosecute the war on terror. A whole lot of other activities happened after 9/11, total information awareness, detention and all that stuff. That is not within the USA Patriot Act, but somehow has entered into the brand of the USA Patriot Act. But your point is valid. The USA Patriot Act itself dealt with a lot of updating the technology, updating the law to the technology, because we had a lot of laws that were written in 1988, and obviously the internet in 2001 was a lot different. Since then, the last 25 years, it has grown even more exponentially. And so, yes, it is a continuing question. I do think that people who are in place in government, people like we were talking about Lisa Monaco, who's the Deputy Attorney General, was in the department at the time. She was grappling with these issues as I was. I'm sure her team is thinking about these things to know how to have all the tools necessary to determine criminal and terrorist networks, but at the same time protect the privacy and freedom of law-abiding citizens. Increasingly, it gets harder. I completely accept that. Just as the practice of law gets increasingly harder. David and I met when the world was paper and pen, and then now it's computers, and then it went from analog to digital, and now it becomes the era of massive data. I was amazed dealing with a case like with 25 million documents, of which 2 or 3 emails gets blown up and shows up in Vanity Fair. You have to understand, there is, on the decision-making side, there is two lawyers, Paul Clement and Dan Webb, at the top of a tower of over 100 lawyers, because that's how many lawyers it takes in order to process a case of this size. Over here, looking at a mountain of 25 million pages of documents. That's a practice of law that you and I are not familiar with. We and by the time Dan goes into court, he has one, maybe two binders that gets. But the trick is, how does Dan and Paul have the ability to access and understand and process these 25 million? You need the entire ability of that entire tower of decision makers to be able to process, search, and make evaluations of that entire mountain of 25 million pieces of data. That's just the practice of law. Think about that in terms of investigations. Think about that in terms of backward-looking criminal investigations. Think about that in all host of other areas of our society where massive amounts of data are being ingested almost on a second-by-second basis with the multitude of decision makers. I think that's when technology also can help. Because now we have the ability to use AI in order to help us through some of that. I wish I had more of that available, so that I, as one of the people in the tower, can have access to one or two of those emails and texts within that mountain. But I think the rules and the use of technology will hopefully help us solve this issue, because it is very, very very, very hard. And like I said, I complain about the fact that the 25 million should have been 5 million had there been a relevance review. And what are the rules that we impose on society, on legal processes, on discovery, in order to make sure that the 24 million that does not belong is not exposed to the world for prurient or non-relevant purposes. But I think you're absolutely right, and that's why I love the things like the Center for Legal for Profession, to allow us to think about the second order and third order issues, rather than just how do we process these 25 million documents for the 100 decision makers, but actually think one level up on thinking about how do we do that more efficiently, and then third level up, how do we do it in advance of the administration of justice, both criminal and civil.
So we will be talking lots more about this over the course of the year and several years, and I hope that those of you interested in this will stay tuned, because it's important for everything, as you said, immigration, for security, for surveillance, for privacy, but lawyers increasingly are in the middle of all of these discussions. Yes, please. Just again, sorry, just a report. No, but it's a great question. The essence of it is, Viet had said that every on-air person and others get training in the First Amendment. The question really was, how are you training on the issue of malice, which is both a legal standard, but it's obviously also a judgment call. And has that training changed, particularly in light of the fact that in the settlement, there is an acknowledgement that the standard may have been met, and certainly whatever was acknowledged in the settlement, those people, whether the email should have been disclosed or not, a lot of what people read looked as though it might have been something at least that somebody should have been thinking about in terms of thinking about training for malice moving forward?
Yeah, great question. Just a point of clarification: we did not make that statement in the settlement. It was a statement that repeats what I say here. I think that despite the settlement, we are very proud of the work of the men and women of the Fox, especially Fox News, and in no way does the settlement or any of the associated developments will it deter us from doing our job as practitioners and purveyors of First Amendment activity. We firmly believe in that duty and responsibility that we owe to the American democracy. Of course, we have to do it responsibly, and that's why the training that we go through. You're right, malice is not. It's not about criminal malice. It's not evil. The forethought is not in criminal law, right? It's just and it's certainly not in the First Amendment. I think New York Times v. Sullivan puts it as the reckless disregard of the truth. And the question then is how much investigation do you have to do in order to be not reckless? And it varies from, you're absolutely, it varies from situation to situation, and it varies from context to publication. And so quite often, we not only talk about the legal standards, but because we're talking to professional reporters and not professional lawyers, we have to put it into real world context. This has been found as malice. We bring up the recent litigation against the New York Times with Sarah Palin. We use a lot of these things, but we all know that appellate cases are the corner solutions. The main is over here. And sometimes when you use appellate cases to teach, people forget that they're corner solutions. They're not the main. And so we talk through in the main of cases. Here is what your responsibilities are. This is what's the right thing to do, and these are the best practices. That's why we have media lawyers who represent a number of organizations who've seen these situations and advise on practical issues. Flip to that, the recognition, if you will, that a lot of our laws relating to the First Amendment and libel was developed at a time when news was in print. And when if you ever watch CNN or Fox or MSNBC, you can see that about half of the programming is guests appearing on shows. Even when we're doing the day part news, we invite guests to come on to comment about the news because it adds a whole level of complexity and richness to engage the government. So no longer do you have Walter Cronkite reading the news 24/7. It would be pretty darn boring. But you have Harris Faulkner reading the news for like 2 minutes and then calling somebody else in to have a conversation about the news. What are your duties before you put that guest on the air? What happens when the guest says something unanticipated? Do you have a duty to correct? All these things are live issues that we have to encounter. The courts have said that in a call-in show you're not responsible for some jackass calling in and saying something bad, but because you're not required to do a 5-second delay just on the off chance that somebody says something bad. But on the other hand, what happens when somebody is making incendiary and false allegations that may be repeated on the air? We have mechanisms to do with that. A lot of news organizations do this. Even on news conferences where maybe a former president was talking, people will put in tape delays just in order to protect themselves, and not just protect themselves legally, protect the integrity of the product. Right, and so because that ultimately is what we're responsible for. We don't like to think that lawyers make editorial or business decisions. We like to think let the reporters and business people make the best judgment of in consultation with legal counsel and not be dictated by the lawyers. Great question.
So let me just
Oh, you don't have to
because
repeat
it is
that one.
I think for the
She
for
asked,
the
what do I
audience.
think about apple pie
Yeah,
and
no, no,
American
no.
flag?
No, she asked a terrific question about how do you reconcile your role as a lawyer, protecting the interests of, Fox News and the organization that you're with, and its right to have its own opinion and reporters, with your own personal experience of being an immigrant, a refugee, an Asian American, in a time in which uh, it's at least fair to say that there has been a lot of editorialization against immigration, against immigrants, and many people, I think she used the word degrading of people on the air. Whether or not it's First Amendment protected, I think she's asking you, how do you reconcile that as a human being?
Right. You brought up Anthony Lewis. I'll start with an Anthony Lewis story. I love Gideon's Trumpet because it's a story about a prisoner who handwrites his own petition and gets the Supreme Court of the United States not only to read it, but to give it its due and recognize a right of redress for the petitioner. If you've ever been around the court, you know how improbable that is because, the court takes in well nigh 15,000 cert petitions a year. It hears maybe, I don't know what the current number is, probably 75 or so. And so that's a lot, a very big mountain with one handwritten petition. And Tony wrote it so well, as you put it, brings the whole humanity of our, not only of the of Gideon, but also of our entire criminal justice system that allows for the least of us to be heard by the highest of the courts. After 9/11, when I was working on, actually after I already finished the USA Patriot Act, but I still was head of legal policy, Tony called me and asked if he can come in and see me. I said absolutely. So we talked about a whole bunch of things, and he asked exactly your question in that context. He said, Viet, you are a immigrant, you are a refugee, you are a boat person, you've gotten everything from this country, and how can you sit here and do your job to oversee, implement the xenophobia that's going on in policy across the administration? I looked at him point blank and I said, Tony, that's a great question. And it's a question I ask myself every day. And all of us as participants in the legal process, indeed, all of us as human beings living the life in America has to ask ourselves, which is, how do we pay fealty to the principles that we believe in that got us to this point, and yet still be true to our profession as well as to our voice and integrity. I told Tony that I take the question in the spirit it was asked, which was there was no personal accusation or animus. All that I can do is I promise you my utmost ability to do what I think is right, to serve my country in the hour of her greatest need with my limited abilities. Some of that people may disagree with, some of it people may thank me for, but always we're in this together in order to help find the right answer. Look at, we at Fox News has 24/7 of a multitude of voices. Does that mean that I agree with every single minute of the air that we air? Of course not. I can't watch all 24/7 of it, but does that mean and that diversity of voices is what makes the product good? That was make for the product. As I say, we have an editorial position that is center right, but it would be very, very boring if there is just somebody saying this is a center right position, let's roll with it. It's all a spirit of debate, of give and take, and that's what makes it encouraging and engaging. You will be very, very, I don't have the numbers specifically with me, but more Democrats and independents, those who self-identify as Democrats and independents, watch Fox News than not. So the majority of Democrats and independents say they watch Fox News other than our competitors. Now, some of that is just pure math, right? When you're number one, you're number one. And so, but it says something when in our polarized society that you can have a product that, for whatever reason, even people who may not agree with you actually watch and engage and engage with. And that's the responsibility that we have, is to not only to be available, but to be entertaining and engaging. So the best way that I can answer your question is I sleep very well at night, knowing that I've done my personal best in order to enhance the civil discourse in this country rather than degrade it. Could we do better? Absolutely, 100%. And that's part of the hard decisions that that we make as certainly as business people, but especially as lawyers.
So Viet, I think that's a perfect note for us to end a conversation that I hope isn't the end, but at the beginning. We are at a perilous time in this country. Actually, I know you agree with this because you and I had dinner last night and we talked a lot about it. And that what is most at peril is exactly the idea of being able to have civil discourse around difference. And yet the differences are only going to magnify as all the issues that we talk about become ever more complex. And, you know, as an educational institution, it is our responsibility to try to provide forums for that kind of respectful disagreement and dialogue among our students and our alumni and those who are watching us online. And it's why I'm very grateful that you agreed to come here, that you agreed to answer any questions that students have. And I just hope that you will continue to engage with us around these issues, because as you say, these issues are incredibly hard and they go to the very heart of what it means to be a lawyer and a citizen and a human being at this time. So I want to thank all the students for the incredible questions that they raised. I hope that we will find ways to continue this kind of dialogue, not just on this issue, but on all of the issues that we have to face in this world. So thank you very much, Viet.
Thank you, David.
Thank you very much.
I appreciate it. Thank you.
Thank you.
Thank you.
It was wonderful.